The Trump administration rescinded the Biden-era zero-tolerance ATF policy, but according to court documents, is still defending it in court. Hello everyone, and welcome back to the channel with toddler screaming in the background. She's having a good time. You'll probably be able to hear her. The Trump presidency is, so far, kind of Russian roulette as far as gun rights. Now, I know there's going to be the folks in the comments reminding us all of the bump stock ban and the take guns first, ask questions later comments, and saying that Trump has never been pro-gun. And I recognize those. But this time around, he claimed to change his tune and used that to mobilize an entire voting bloc of gun owners. Made his whole Second Amendment executive order, the task force, blah, blah, blah. Then he picked Pam Bondi. Then progress stalled. We've had wins, we've had losses, we've had pure WTF moments, and this one here is one of them. Because the Trump administration has said that zero tolerance is gone and that the policy is reversed and that FFLs who were caught up in that Biden-era policy can apply to get their licenses back. You may or may not be able to hear Liberty Toddler's opinion of this in the background. I believe we have a case of either chase or monster hunting happening outside this door. Maybe she's hunting ATF agents, I don't know. But according to court documents, his DOJ is defending the policy and says that lawsuits against it are null and void because the Second Amendment doesn't protect the right to sell guns. Now you would think if it protects the right to acquire them, well, we have to acquire them from somewhere, and that action should also be protected. These allegations are coming from the gun owners of America, and given their track record, I'm inclined to believe them. But you don't have to take my word for it, or theirs. We can look at the documents and you can decide for yourself. GOA filed a lawsuit against the ATF in July 2023 challenging the zero-tolerance policy. This was the one where FFLs were losing their licenses and getting penalized over simple clerical errors, putting a date wrong, missing a digit, forgetting to check a box, that sort of thing. They were deemed willful violations of rogue gun dealers and basically kicked off the team. Tons of FFLs were caught up in this net. I have covered many of them on this channel. They were raided, they had the ATF show up and handcuff their children, they were forced into signing paperwork, they lost their livelihoods. Now, the Biden administration argued at the time that the policy did not put a burden on the Second Amendment. In 2024, a Biden DOJ brief said that the Second Amendment does not protect a right to purchase guns from a preferred local dealer indefinitely with minimal convenience. They also argued that it never hurt anyone. Later that year, a district court dismissed the case, but GOA kept going, bringing the case to the 8th Circuit Court of Appeals in order to set a permanent precedence. Otherwise, the next administration could easily just put the rule back. Or a worse one. As GOA Senior Vice President Eric Pratt told the Daily Caller, the case isn't moot because ATF policies aren't law and don't go through the traditional formal process of rulemaking. They could do it at the drop of the hat if they wanted, and just because they backed down this one time doesn't make the case against their rulemaking null and void. GOA wanted to press the case also to prove the harm that it caused on public record. In April, the Trump administration repealed the rule, and Pam Bondi even acknowledged that the policy unfairly targeted law-abiding gun owners and created an undue burden on the Second Amendment. In May, ATF Acting Director Dan Driscoll issued an updated policy also acknowledging many FFLs were unfairly penalized for simple mistakes and clerical errors. But now, according to communications with DOJ lawyers and court filings, they said the DOJ has no plans to abandon its previous arguments. They're not arguing that the lawsuit is moot because the policy has been rescinded. The DOJ is still arguing that the lawsuit is moot because the Second Amendment doesn't protect gun sales. Now, this is quite the problem here because, as GOA's brief points out, the DOJ's continued litigation position is at direct odds with the public statements about the policy. In fact, defendants actually agree that the policy is unconstitutional. outside of court, that is. Members of the Trump administration, including defendants, have publicly repudiated zero tolerance as the blatant statutory rewrite and attack on the Second Amendment that it is. Thus, to rule in defendants' favor, this court would have to overcome defendants' own agreement with plaintiffs' arguments, ignoring the chorus of support plaintiffs' position now enjoys from numerous websites ending in .gov. But the problems for defendants' unserious defense of zero tolerance do not end there. Their revocation policy's own title, zero tolerance, belies their in-court representations that it did not punish inadvertent paperwork errors. So too does the policy's plain text, which claims that certain violations are willful just because they occurred. Defendants' enforcement history likewise supports plaintiffs' position, as ATF repeatedly moved to revoke for inherently willful violations, only to realize they were not willful at all. Tellingly, not even defendants' own employees adopt the party line, as many testified that zero tolerance tied their hands, mandating a predetermined result in every case and depriving them of the discretion the statute requires. Thus, it would appear that only defendants' lawyers at the Department of Justice still believe in zero tolerance, offering post hoc rationalizations that literally no one else still believes. That should undermine any residual confidence that the district court got it right, and, for the reasons that follow, plaintiffs respectfully request that the district court's judgment be reversed. To add to the weird controversy around this, two of the original lawyers from the case under Biden are still handling it. And on top of saying it's not a Second Amendment issue, they're arguing that the zero tolerance policy didn't actually harm anyone as another argument for dismissal. According to the DOJ, plaintiffs make no allegations whatsoever that the adverse action policy, being the zero tolerance rule, has prevented someone from keeping or carrying firearms they already own. And to the extent plaintiffs claim that the AAP burdens a constitutional right to acquire arms, they do not identify a single individual who is unable to purchase firearms or a single jurisdiction whose residents cannot buy firearms. This is the argument that the DOJ says they will continue to make in this case. Here is GOA's response. For starters is defendants' steadfast denial that their adverse action policy, AAP, caused any legal injury or consequences to gun dealers, citing the DOJ's own brief. That is not the president's understanding. As the White House 2026 budget request observes, the previous administration used the ATF to attack gun-owning Americans by the revocation of federal firearms licenses, which shut down small businesses across the nation. And while defendants argued to this court that plaintiffs' fear of mass FFL closures is not borne out by the ATF data, ATF brief at 29, the White House acknowledges otherwise, that ATF was weaponized to end the livelihoods of law-abiding small business owners, which led to a nearly six-fold increase in enforcement actions. Indeed, if the zero-tolerance AAP never caused any legal injury, ATF brief at 16, there would be no reason for defendant ATF to invite any federal firearms licensees that had their licenses revoked or surrendered under the enhanced regulatory enforcement policy to reapply and be judged under the new standard now. Defendants cannot both 1. Scramble to fix the harm they caused, and 2. Claim to this court that no harm ever occurred. Also consider defendants' adamant denial that the AAP callously punished unintentional human error and that inadvertent paperwork errors led to costly revocation hearings. The brief breaks down every single one of the ATF's and DOJ's arguments on the ways that the policy didn't cause harm, with proof in the DOJ's own statements about every way that it did cause harm. It also points out that the DOJ continues to argue in this case that the Second Amendment does not apply to selling guns or being able to buy them from licensed dealers, which is absolutely ridiculous. Otherwise, anti-gun states could, instead of banning owning a gun, would ban selling all of them completely. Though goodness knows they have tried to find sneaky ways to do that, and it hasn't worked out for them. The brief goes on for nearly 40 pages and then finally breaks down the exact numbers that the DOJ is claiming in court, no harm, no foul. But we saw an 11% decrease in FFLs under this policy during the Biden years. If a double-digit decrease in the availability of Second Amendment arms does not count as an infringement, it is hard to see what would. Certainly no court would turn a blind eye to an 11% reduction in the nation's churches or bookstores, coinciding with a zero-tolerance government closure policy targeting the same. Such government action more than implicates the Second Amendment, certainly at the pleading stage, and the district court was wrong to conclude otherwise. Now, we don't know if this is DOJ lawyers going rogue or the DOJ saying one thing in public and a different thing in the courts. Some people even think this is another 4D chess thing with the DOJ setting itself up for a loss in court on purpose, despite the previous dismissal. But it doesn't look good, because whether it's rogue lawyers or not, it's people attached to the DOJ arguing in defense of the ATF and the policy, saying one thing in public and another in private, saying that even if the policy were still on the books, it wouldn't matter because it was constitutional and never hurt anyone. The DOJ is essentially arguing that despite public statements to the contrary, the Biden administration did nothing wrong in creating and enforcing this policy. And if this is indeed just a couple of rogue DOJ lawyers, then Trump needs to get his house in order. All right, ladies and gentlemen, that is it for this video. You guys know the drill for all of the algorithm things. Please do them. And as always, thanks for tuning in. Stay safe out there and happy shooting.